Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, a couple of weeks ago, we did a video about a suit pending in the Northern District of Texas as it relates to ATF's new rules on frames and receivers, in particular, ATF's new regulations on unfinished frames and receivers, or what we like to call 80% lowers. Now, in that video, I said, hey, some pretty encouraging news. An injunction had been granted, and that is always positive news if you are the one moving for the injunction. However, there appears to be even more positive developments coming out of that, and I think you ought to be aware of them. So today, let's spend a couple minutes and talk about, is ATF losing control of unfinished frames and receivers? Okay, before we get going down the road we are going down, proud to announce that this video is being brought to you by Legal Heat. That's right, the nation's largest educator of concealed carry classes. Legal Heat has now taught over 200,000 people nationwide since they started business in 2005. Now listen, for my Washington viewers, they have taught over 4,000 people in this state, and yes, you can find a class in any one of these locations right here. For those of you watching somewhere out of the state of Washington, congratulations, you are living freer than we are, but you too can find a class close to your backyard by visiting them at mylegalheat.com. That's mylegalheat.com. Now listen, for everybody, no matter where you are, if you find a class and you want to sign up, use the promo code Washington Gun Law. That's Washington Gun Law, all one word, and you will receive 10% off. So for more information, visit them at mylegalheat.com. Okay, so the case that we're talking about today is a case that's filed in the Northern District of Texas down in the Dallas-Fort Worth area. It is being spearheaded by our good friends over at the Firearms Policy Coalition. And I'm going to put a link for them down below, because if you really are looking for an organization that you get a lot of bang for your buck, pardon the pun, but an organization that really is out there fighting like holy hell for your Second Amendment rights, it is the Firearms Policy Coalition, and so is the Second Amendment Foundation, and so is Gun Owners of America. And I'm going to put links for all three of those organizations down there, because I really think that they are in the trenches fighting all the time. As we know, the ATF has published a new rule on frames and receivers, and it had a lot of us freaking out when we saw the first few versions of the rule. And now that the final rule is published and in effect, we're beginning to try to get our head around it. Now, as it relates to finished frames and receivers, there's not a lot in the new rule that's any different from the way we used to think about it. However, when it comes to unfinished frames and receivers, oh yeah, there is a whole new set of rules. Because as we know now, according to the ATF, there is this spectrum along the manufacturing process where at some point a chunk of metal will cross the magic threshold and suddenly become, even though an unfinished frame or receiver, regulated as though it is a finished frame or receiver. And there's many criteria that goes into that. I'm not going to bore all of you with the details of that here, but you can learn about it in these videos right here, because this is where we have discussed about them. Now, the Firearms Policy Coalition didn't want anything to do with this, and they filed a suit in the Northern District of Texas to enjoin, to stop the federal government from enforcing their restrictions on unfinished frames and receivers. The trial court in the Northern District of Texas actually granted that injunctive relief. That is a very positive development. They basically said that the federal government could not enforce the unfinished frames and receivers rules in the Northern District of Texas. But the plaintiffs, in this case the Firearms Policy Coalition and VanDerStok, who is the actual named plaintiff, went back to the court and said, you know what, we actually need a little bit more injunctive relief. You see, one of the named plaintiffs is a company called Tactical Machining, who manufactures these unfinished frames and receivers, and they asked for injunctive relief so that they could, in fact, continue to sell the products. Their customers would not be subject to any type of criminal liability as well. So this is a big step where you're basically asking the court, hey, we want to continue to do business as though this rule does not exist. Now, let's go back in our little time machine here for a moment, because we remember that when we are asking for an injunction, when we're asking the court to step in before all the matter has been decided on the merits, and we're asking to take kind of an interlocutory step of step in and stop this right now while we settle this argument, The plaintiff, in this case VanDerStok and the Firearms Policy Coalition, they have to demonstrate two things. The first thing they have to demonstrate is that they will suffer irreparable harm if the law is enforced. So you can understand, for the company that's manufacturing these things, you're basically putting them out of business. You're basically rendering all of their employees unemployed. And yeah, there is some pretty irreparable harm. For individuals, they could be subject to criminal liability, incarcerated, fined, and that certainly is irreparable harm. But in addition to showing the irreparable harm, no court is going to grant injunctive release unless you also demonstrate that you're likely going to prevail on the merits of the argument. That is, that VanDerStok and the Firearms Policy Coalition has to show the court that in all likelihood the law is on their side and that ATF truly did overstep their boundaries here when they decided that they had the authority to regulate chunks of aluminum. And when we take a look at ATF's whole new set of rules as it relates to frames and receiver, the one area where the ATF is most definitely susceptible to a constitutional challenge here is in their regulation of frames and receivers. Because let us remember that Congress has delegated ATF the authority to regulate firearms. ATF does not get to define what a firearm is. Congress has defined that through statute. And unfinished frames and receivers, no matter what the ATF says, does not constitute a firearm under federal law. Unless Congress delegates that additional authority to the ATF, which is not going to happen anytime soon, they likely do not have the authority to take chunks of aluminum, encompass it into their jurisdiction, and now regulate it under federal law. Listen, once again, the case is VanDerStok v. Garland. We're going to put a link for that down below, and as there are more developments on this case, we will be sure to keep you posted. In the meantime, if you have any questions about this or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.